I'm gonna do a little hand loading here and just kind of sit at the bench and talk about something. My wife and I just went for a walk, and of course I'm a motor mouth, so I'm just talking about things that are on my mind. And often what's on my mind is related to a specific topic, and I'll just get into this. This whole thing starts with some gun store in New Jersey. Some gun store in New Jersey sold some ammunition to an undercover cop. And in New Jersey, there is a data gathering and background check scheme for ammunition purchases similar to California. Now, I think this gun store did the right thing in not following a law that they deem to be unconstitutional or void. So what happened apparently, and I don't know all the details of this case, but the synopsis seems to be that an undercover cop bought ammo from this gun store, and then now the district attorney is suing the guy in civil court for a violation of this law. And part of the issue comes from that people like me are wondering why the district attorney isn't filing criminal charges. And so then my number one answer for why that might not be is because he knows that in a criminal trial, his law would not hold up to constitutional or other lawful scrutiny of a judge. So in civil court, perhaps there is a chance that a jury full of ignorant people, because we all know that juries are hand-selected, not to be a jury of our peers, but hand-selected to be a jury of an outcome, and we already know that. Part of the reason why that is our own fault, because we all have this hunt for justice instead of a hunt for a just application of the law. And so what we call justice often is vengeance. But that aside, we're typically in a position where we get a jury that's either ignorant to the details that make the case different than what it appears to be, and they're hand selected to do so. Why on most tax cases, anyone who believes that it is wrong or unconstitutional, who literally would be a cross-section of society, they just get disqualified from serving on that jury. So, and that led me to, because I think a ton of what the government does is unlawful and unconstitutional on its face. And so they've figured out slowly how to basically discourage by proxy things from happening, right? Like we all know that pistol braces are currently legal as a beagle. Braced pistols. But there's almost nowhere where I can go and buy one. And so we've got a perfect situation of where nobody wants the heat, and so it might as well be illegal just based off of availability alone. And similarly with how about assault weapons and assault weapon parts and 30-round magazines in Washington? It's very likely that that's unconstitutional. It's very likely that the whole entire thing should be ignored and that it's unlawful on its face to even try to make a law regarding such things. But there's so much heat that most people are going to comply anyways, and so the law might as well be lawful and enacted and in place by default. It's you know what I'm trying to say here. I'm not the best at explaining, but I'm sure you know what I'm trying to say. So that brought me to the thoughts on another case where, like, we've already got an outcome on frames and receivers, and that's in federal court. We've got an outcome on frames and receivers. But a man, and I might have this wrong a little bit, but the details of the case are not really pertinent to the point that I'm going to make. So where I think it was Massachusetts, but that's where I might be wrong. But it was a state arrested a man for unlawful possession of unserialized firearms that he had made himself. And I think they busted him for felony manufacturing without an FFL, where manufacturing for personal use does not require an FFL. Never has and never will. And they also busted him for illegal possession of a silencer, which I'm pretty sure was just a blast canister. I'm pretty sure from the photos that I saw, it was not a suppressor. And this man got, last I knew, he got sentenced to 10 years in prison. Now, the funny thing about this particular case, too, is that the state police got tipped off by the Department of Homeland Security as to what the behavior of this man might be. And I can't remember if it was from credit purchases or bank accounts that the Department of Homeland Security was gathering data without a warrant about this guy. And then tipped off the state police of Massachusetts, hey, there's this guy, a resident of your state, who may be committing a state felony. Which, that's very interesting. Just so happens this man's skin color was black. And I'm pretty sure he was held without bail. And then was sentenced, and now he's awaiting appeals because obviously what they are doing to him is unconstitutional. And he's awaiting his appeals in prison because he was sentenced. And that brings me to my third story. My third story is that a man in California gunned down a man and his wife who were out walking their dog slightly after dusk, and he shot the man multiple times in his abdomen and arms and chest, and he shot the woman multiple times in the abdomen, arms, and chest, and the woman passed away. And the man has been hospitalized and been in and out of various surgeries since the ordeal. And the man who shot them is being charged with negligent discharge of a firearm resulting in death and illegal night hunting. Now, where I come from, if you shoot at noise without identifying your target, that is more than negligent when it results in someone's death, because we've been taught since we were very, very young that if you shoot at noises, that there is a much greater likelihood that that noise is a person than that noise is an animal that you're hunting. So in my view, in my estimation of the world, you've got shooting at an animal, missing, and hitting a person behind that animal. That would be negligent discharge resulting in injury or death. Shooting at a noise of an unidentified target would literally be murder one. The same as driving drunk and killing someone is murder one. You drive drunk and someone gets killed because of your driving drunk, that is murder one. You premeditated that you had a likelihood of getting in a crash or hurting someone. You chose to do it anyway, knowing that the likelihood was that you were going to hurt someone, and you killed them. That's murder. Whether any of that is right, wrong, or otherwise, I'm just putting together legal precedent, okay? So, to me, he committed murder one and attempted murder of the man. But what he got was negligent discharge resulting in death, which there's an argument that that's also true, and night hunting, which I don't think this man was hunting. The guy looks like a G unit, and I mean, you know, you can't really judge a book by its cover, but when you factor the looks of the man in with the behavior, which is that he opened fire on 2 people after dark and shot until his magazine was empty, then fled the scene and turned himself in later. It just has a smell to it. So, and I'm not a juror on this case, so to me, it just has a smell to it. Now, what's interesting about this case is that both of these defendants, their skin color is black. And so what I'm kind of using this as an example of is that our system, racism is not exactly like a key to analyzing this case, because in this particular case, both of these 2 defendants are black. But one, I'm just going to guess, and maybe I have it wrong and maybe I don't. One looks like a G unit who is in Southern California, who was already breaking a known law while he committed an act that I think is attempted murder. And the other one is a man who, within the confines of his own home, was building weapons and hurt no one. And he got held without bail and got what I consider to be railroaded. He got sentences that I think were not appropriate applications of the law, considering he was a first-time offender, and if you even call those offenses, he had no prior criminal record. And So I think that they misapplied the law to him based off of, obviously not his skin color, but based off of his political ideology. That he is a man who's behind enemy lines in a non-permissive environment, breaking the king's laws, defying the king's edicts, and so they want to make an example out of the big, bad, conservative guy who's responsible, wasn't hurting anybody, but doing a bad thing and making the king look stupid. Meanwhile, on the other hand, you've got a man who completely looks the part, and there's an old saying called, if the shoe fits. He looks like a gangster. If not a gangster, then just a scumbag, just a dirtbag, who his actions have cost someone their life, and he's out on bail and facing pee-pee spanking charges. But he's probably going to end up with the same 10 years as a man who didn't kill someone, when I think at the end of the day he committed murder 1 and attempted murder. Now, another part of the issue is the man who survived the attack in California, the victim, the surviving victim, someone, I don't know if it's his legal team or whoever is sponsoring his case, someone has convinced him to be angry that the killer is out on bail. Now, my understanding is that bail, along with the right to innocence until being proven guilty, is a constitutional right in this country. So we've got a guy who is angry, rightly so, as a victim of attempted murder, but that he is misguided, he's misplaced his anger. Instead of being angry that this man's facing illegal night hunting and negligent discharge charges instead of murder, he's mad that he's out on bail, which is literally a constitutional right to be turned loose on bail. And what I'm actually angry about, and what I think Americans should actually be angry about, isn't that this killer's out on bail because he promised to go back to court and face the music. And if he doesn't, then he faces another set of charges. Bail is a right that as an American, you're entitled to, as long as you're not at risk of failing to appear, fleeing, trying to flee the country, or hurting other people while you're out on bail. Now, this is a man who, regardless of whether you think it's murder 1 or not, he turned himself in. I don't think he's a flight risk. I think he's a scumbag, but I don't think he's a flight risk. So he's out on bail, and most likely rightly so. But why was another man treated differently, who was also a first-time offender, not a flight risk, and also didn't commit even a violent crime, treated to the same application of the law? Which brings me to my ultimate point, which is that I think in today's society that, especially as it pertains to certain subjects, if it has to do with gender affirmations or the denial of such, you are going to get treated with a much stiffer application of the law, which is supposed to be indifferent. If you are a law-abiding conservative gun owner, you are going to get a stiffer application of the law, partly because of the you're supposed to know better, which negligence is not supposed to be, negligence and ignorance are not supposed to be any excuse for the law. But you are going to get treated to a much stiffer application of the law as a law-abiding conservative who made the king look stupid, or who broke the king's unconstitutional edicts, than you are if you literally murder someone and commit attempted murder. And one can only guess at the reasons, but it sure, from the way it looks to me, it really, really looks like a concerted attack on people who believe a certain way. Now, whether they're conservatives or not, right? Like, I know some very, very liberal-minded people who own their guns lawfully and are in general respectful and fearful of breaking the law. And so it's not necessarily that is a conservative person, but that the person who is respectful of the law and fearful of the law and its repercussions is exactly the one who's going to get railroaded the hardest by our system, and not the person who blatantly, flagrantly violates the law, even when it causes the death of someone. So that's my rant. That's all I got to say about that. I think I beat this horse into the ground enough, but there's a problem in this country, and it's not people getting out on bail, I'll tell you that. It's a misapplication of the law, a disparate application based on what looks like the political and moral ideology of the defendant. And I really think I've got evidence to support that.